Hello everyone, welcome back to yet another episode of Tax Mantra. The topic of today's session is the much deliberated and debated paradigm shift in reassessment regime, a new tangle. As we all are aware that the Finance Minister, while presenting the Union Budget 2021 of India on 1st February 2021, amongst other measures, recommended the paradigm changes to the existing provisions relating to reassessment, which thereafter became Finance Act 2021. Accordingly, the Finance Act 2021 has done away with the existing legal framework for reassessment to be conducted on or after April 1, 2021. Henceforth, reassessment shall be framed under the amended provisions of Section 147 to 149 and 151 of the Act. The newly inserted 148A mandates that before issuance of notice under Section 148, the assessing officer shall conduct inquiries if required and provide an opportunity of being heard to the assessee. After considering the reply, the assessing officer shall decide by passing an order whether it is a fit case for issuance of notice under Section 148 and serve a copy of such order along with the notice to the assessee. The assessing officer shall, before conducting any such inquiries or providing opportunity to the assessee or passing such order, obtain the approval of specified authority. The amended provisions of sections 147 to 149 and 151 of the Act came into force from April 1, 2020. However, considering the ongoing pandemic in the country, the government undertook various steps, as part of which taxation and other laws, relaxation of certain provisions ordinance 2020 was promulgated by the Honorable President on March 31st, 2020, according to which several limitations prescribed under various laws, including the Act, were extended. Thereafter, since the difficulties faced by taxpayers due to the ongoing pandemic were not relieved, the Parliament in September 2020 enacted the Taxation and Other Laws, Relaxation and Amendment of Certain Provisions Act 2020, wherein, on the heels of the earlier ordinance, civil time limitations prescribed under the Act were relaxed and extended. Accordingly, where time limit for issuance of notice under Section 148 as per the time limit specified in Section 149 and sanctioned under Section 151 of the Act was to lapse on March 31st, 2021, the same stood extended up to 30th June 2021. By way of the video of Tax Mantra, we have attempted to unlock the challenges and discuss several technical questions which have crucial bearing on the reassessment notices being issued to the taxpayer under the old reassessment regime. To begin with, may I request Mr. Jain to briefly explain the exact debate relating to the validity of notices for earlier assessment years 2013-14 to 2017-18 within the extended period of April 1, 2021 to June 30th, 2021.
I think you summarized the entire controversy related detail, but before I come to the exact debate which is bothering taxpayers as well as the revenue and also the courts at the moment is basically, as we all know, that earlier the scheme of assessment was under Section 147, prior to which a notice under Section 148 has to be issued, and there were certain jurisdictional conditions which were required to be followed by the assessing officer prior to issuance of a 148 notice, which was basically he was required to record reasons on the basis of which he had a honest and a bona fide belief that there is any escapement of income. Now, what has happened is by the Finance Act 2021, altogether new scheme of reassessment has been enacted in the Income Tax Act and which is applicable from 1/4/2021. What basically the new scheme requires the assessing officer to do is he cannot directly issue you a 148 notice. Prior to the issuance of the 148 notice, he must possess some information. Now, what actually connotes this information has been defined in the Act itself to mean either the information which has been flagged by the risk management strategy as may be notified by the CBDT, or information may be in the form of a final objection of the CAG, which indicates any escapement of income on the part of the taxpayer. Only on these two bases, the assessing officer can start the process of initiating the proceeding. Now, even before issuing a 148 notice, what he is required to do is he has to follow the procedure, which is now provided in section 148 capital A of the Act. What broadly section 148A requires is that once he gets the information, on the basis of that information, he must conduct his own inquiry. These are inquiry which he does with at the back of the taxpayer. Once the inquiry is conducted, and on the basis of the result of the inquiry, he still feels that the reassessment is to be initiated. In that situation, he is required to give a show cause notice to the assessee as to why a reassessment proceeding should not be initiated. And this show cause notice must be accompanied by the information which is already in the possession of the assessing officer, and also the reports of the inquiry which is conducted on the basis of that information, and on the basis of which he still feels it is a fit case of reopening. The assessee has been given the opportunity by way of the show cause notice to file its objections to whatever the information and the inquiry report which is confronted to the taxpayer or the assessee. He will file its objection, and thereafter, after considering the objections of the taxpayer, the assessing officer is required to pass a formal order under section 148 capital A itself, whereby he must state as to why this is still a fit case for initiating the reassessment proceeding. Now, thereafter, once the assessing officer proceeds to issue you a 148 notice, that 148 notice has to be accompanied by this formal order, which he passes under section 148 capital A of the Act. Now, as you will notice that there is a complete shift in the procedure of assessment, which was there prior to 1/4/2021 and post 1/4/2021. In fact, what basically has happened is the entire GKM principles or the procedure of GKM principles, which required the assessee to first seek reasons, file its objections, and the assessing officer disposing of those objections by way of a speaking order, has been codified in the form of the procedure itself by enacting section 148 capital A and reintroducing section 148 of the Income Tax Act. Now, the entire controversy has arisen because of the overlap of the old procedure as well as the new procedure, and this has primarily happened because of the extensions which has been given from time to time because of the COVID. For example, assessment year 2013-14, if we were to adopt, now in the normal course, the 6-year limitation period would have expired on 31st of March 2020. But initially, by virtue of an ordinance and subsequently in the form of the Relaxation Act, these the amendments were made, the limitations were relaxed, and it was extended to 31st March 2021, and later it was further extended to 30th of June 2021. Now, for this 3 months period from 1st April 2021 to 31st June 2021, there was an overlap. By virtue of the new procedure which has been enacted in the income tax itself, a new procedure had kicked in from 1st April 2021, and by virtue of the Relaxation Act, the old notices were being issued under the old procedure till 30th of June 2021. There would have been a issue as to which procedure is to be followed in such cases where the assessing officer has issued notices by taking benefit of the extended limitation. The notification which has been issued under the Amendment Relaxation Act is specific. There is an explanation which was inserted in the notification, wherein it was provided that insofar as the notices which are being issued by taking the benefit of the extended limitation till 30th of June 2021, they will be governed by the old procedure. Now, this explanation which has been inserted in the notification has become a matter of debate and dispute, because the case of the taxpayers is that once a new enactment or the new provision or the new procedure has been enacted in the Act itself by bringing in section 148, 148A, etc., for any notice to be issued after 1st April 2021, it can only be issued under the new procedure. Whereas the explanation says the notices which are issued by virtue of the extended limitation, you can follow the old procedure. So that is in sum and substance the debate or the dispute as to by virtue of the explanation, one can defer the implementation of the new procedure of reassessment. That is the entire dispute.
Thank you, Mr. Jain. So the follow-up question which I have for Mrs. Shah is, while the deadline for issuing notices under old law was extended to June 30th due to the pandemic, the question that pops up is whether the notices issued after April 1, 2021 are valid in the eyes of law. The connected issue is whether substantive part of the law can be changed due to a notification or the ordinance, and what is the validity of such notification issue.
Thanks, Punita. I think you have raised a very pertinent and a very important question, which is actually bothering most of the taxpayers in the country today. And so for the validity of notices, which you're asking, that what is the validity? These notices which have been issued after 1st April 2021 under the garb of notification issued by Taxation Relaxation Act, saying that there is an extended time period which is available with the department, and the law which was available prior to 1st April 2021 will hold the field till 30th June 2021, has been challenged by various taxpayers before various high courts, and the matter is sub judice. Most of the high courts like Delhi, Bombay, and Calcutta have granted interim relief in favor of the taxpayers. The basic and the major contentions which the SSCs are taking in these petitions are basically twofold. Number one, any action that is taken post the amendment of a procedural law or a procedural section, we can say, would have to abide by the new procedures stipulated in the Act. And secondly, notifications which are issued under the Taxation and Relaxation Acts are ultra vires of the Act insofar as they contain the explanation clarifying that pre-amended section 148, 149, 151 of the Act shall govern the issuance of notice. So the question really boils down is, by virtue of a notification, which is a delegated legislation, can the date of implementation of a statutory provision stipulated in the Act can be varied? So that is a question which right now the courts are considering. And so far Calcutta High Court is concerned, they're also considering the constitutional validity of Taxation and Relaxation Act. Right now, they have just issued notice and the matter is sub judice. But so far wires are concerned, wires of notification are concerned, that is being challenged both before Bombay High Court and also before Delhi High Court. So the fundamental principle which boils down from these challenges are that pursuant to 1st April 2021, there is a complete overhaul of the reassessment mechanism. So the earlier, prior to 1st April 2021, the GK and Vaish Act, the Supreme Court judgment was ruling the field. In fact, there was no codified law in that context, but however, as a convention, it was being followed, and even the high courts were entertaining the writ petitions filed by various SSCs. But the procedure which was being followed umpteen years has now been codified in the new legislation, and there is a new procedure which is 148A. So 148A basically stipulates that there are various steps which are laid down under 148A, and SSC before even issuance of notice has to follow those procedures. And law is well settled. In fact, Taylor versus Taylor, it's a celebrated decision. Most of the people who are practicing on this side are aware that if a legislation lays down a particular act has to be done in a particular way, it can be done only in that way and no other way. So if legislation has laid down a new procedure, which is effective from 1st April 2021, and the procedure are basically a safeguards, and even it's a check for the SSC officer before issuing of notice that you have to conduct inquiry, you have to give an opportunity to the SSC so that he can at least present his case before an issuance of a show cause notice. So if these safeguards are there, and if this is a check which is already incorporated in the Act, then there is no reason why the assessing officer, while issuing notice after 1st April 2021, will not abide by these procedures. Secondly, there's one more argument which the department is taking, that for assessment year 13-14 and 14-15, since the time limit was expiring, and that's how the Relaxation Act had given them that power to issue notice under the old law by virtue of the Taxation and Relaxation Act. But there is a big question mark for subsequent years, because for subsequent years, if notices have been issued after 1st April 2021, then also the department has not followed the procedure as stipulated by the new legislation. So in a way, it's only the courts which are now seized of the matter. There are multiple issues which are arising, which has to be now settled by the courts going forward.
Thank you, Mrs. Shah. What are your views, Mr. Vora, on this issue?
I heard my learned predecessor speakers talking about the paradigm shift in the movement from section 148 to 148A made by the Finance Act 2021. I am also aware that courts across the country are dealing with a spate of writ petitions challenging the issue of notices post 1st April 2021 relating to the assessment years prior to assessment year 2021. Uh, Basically, I think the courts will eventually have to deal with several controversies and several issues, some of which I may seek to enumerate as follows. The first will be whether a notice issued post 1st April 2021 and up to 30th June 21, in terms of the extended limitation provided by the Relaxation Act, can be said to be barred by limitation. Now, in my view, the Limitation Act has extended time limit for several actions to be taken. It is basically the issue of notice under section 148 that is being contested by the taxpayers on the ground that this notice could have validly been issued only up to 31st March 21, and since the time limit has expired, the Relaxation Act cannot seek to revive the limitation which had already expired or exhausted itself. So that's the first controversy. The second is assuming, for the sake of argument, that the notices are within time, then whether the notices should have been issued in terms of the new procedure prescribed under section 148A or the old procedure as pointed out by the or mandated by the explanation in the Relaxation Act, in the notification issued under the Relaxation Act, that should govern, which I think Rohit alluded to in greater detail. So the question, I think, before we get into this controversy, the question will be whether this amendment made by the Finance Act 2021 is a procedural amendment or is a substantive amendment. Normally, amendment relating to making of an assessment is a matter of procedural law, and the law that stands on the first day of the assessment year is the one that will govern the assessment or reassessment for that year. But I think a larger question that arises whether this is actually a substantive amendment or one can only regard it as a procedural amendment, in which case the conclusion will follow whether the new procedure should take over or it should be guided by the old procedure. That's one aspect of the matter. The second controversy is whether this notification issued under the Relaxation Act, and specifically the explanation which mandates that the old law needs to be followed for notices issued between 1st April 21 to 30th June 21, whether that can be said to be beyond the powers that may control issue of a delegated legislation. So I think that's the second issue that may arise when the courts were to deal with the matter. The third issue will be whether, again, the jurisdictional conditions relating to pre-1st April 21 law or the jurisdictional conditions, and I rarely find any jurisdictional conditions under the new law, whether they will govern the exercise of jurisdiction by the assessing officer while seeking to initiate proceedings under the amended law. So I think those controversies will arise. Now the issue will be assume that the court were tomorrow, when the matter is finally decided, hold that the notices issued post 1st April 21 are valid in terms of limitation, are to be governed by the old law. I'm just putting that hypothesis. Then in that situation, can you still claim the benefit of the jurisdictional conditions under the old law? Namely, that if there is a change of opinion, the initiation of proceedings is invalid. If you have been previously assessed under 143 and there is no failure on the part of the assessee to disclose fully and truly all material facts, can in that situation it be said that the assumption of jurisdiction is contrary to law? So all those issues, according to me, are going to engage the attention of the courts, and one will have to find a complete answer to to all these questions in order to resolve this controversy once and for all. And therefore, I think for uniformity of views, it is important that the courts take the matter in its complete dimensions to come to a final resolution. So I think we'll have to only wait and watch to see how the controversy settles down.
Thank you, Mr. Vora. Having regard to the complexity involved in the matter that have ultimately landed up in the courts across the country, we feel it would be too early to concede to the legislative intention behind washing away the well-existing and judicially evolved reassessment regime, which was so done in anticipation that the new system of reassessments would result in less litigation and would provide ease of doing business. But it seems that this is not the end, but the beginning of a fresh stream of litigation. We shall continue in part 2 with our deliberations on another set of complex issues on this topic and way forward for the taxpayer against the 148 notices being issued post April 1, 2021 under the old reassessment regime. So stay tuned for the part 2 of the present series on new reassessment regime. Thank you.